MOJ submission number 2 on the list. And in fact, Honorable Chair, if we can formally just tender every single document submitted by the ministry, marked MOJ 1 to MOJ 11. MOJ 1 being a cover letter accompanying the submission, all the way through MOJ 11 being the government white paper. I would ask that as we proceed, perhaps the Secretariat would aid in affording the Honorable AG a copy of this itemized list to us, for him to confirm the submissions.
That's fine. You can go ahead. Thank you.
So if the chair is comfortable, if the committee is comfortable, we would propose that we take the references in our list as proposed, as before you, Chair.
That's okay. That's
so
fine.
To continue, legal notice number 2017 is MOJ 2. I will refer the committee to MOJ 2. And for the benefit of the AG, it's the legal notice 15 of 2017. Honorable AG, given the findings in the said report.
Which report?
The report highlighted in paragraph 1
okay.
of legal notice number 15 of 2017. Did the ministry record show why the government opted for a commission of inquiry model instead of pursuing other mechanisms? Other mechanisms, if I can suggest, would be an investigation by the by the Auditor General, the IGP, or even a special prosecutor or a task force. If you could guide the committee.
To be honest, I never expect I would be giving on the mind of the ministry for a time that I was not in the ministry. So unless it is memorialized in writing, then I can search for those documents. But what was the thinking at the time? I don't think I'm competent to testify to that.
I appreciate that answer, Honorable AG. The committee is of the opinion that the ministry is a ministry of continuity, it's a ministry of record, and you have undertaken to provide those records if they exist, and I do appreciate that. The committee rather would still like some clarity in some of these issues. Now, if your stance is that you do not believe you are the proper witness to speak to those issues, then perhaps we would put it in form of an opinion as current AG.
Yeah, I'm not too sure I'm being heard clearly. This is about thinking. These are human beings. So other than records, the human thinking that went into the decision making, I cannot testify to that. How was it there? I cannot even express an opinion on it.
Chair, we would move on the account that the AG would provide the committee.
Yes, we'll check for all the documents that we can find relating to that period. Any document that, while the thinking was going on, anything that they reduced into writing and is available, we'll provide that. But what thinking went into the decision making, I cannot testify to that.
Thank you, Honorable AG. In that case, we proceed to a suit filed by your office in May of 2017. Again, that is before you came into office, but on this issue, the committee feels that since records have been submitted from your office, you should be able to speak to it. This is a suit between the Attorney General and Yaya AJJ Jammeh in May 2017, which produced a ruling, an order of the High Court issued on the 22nd day of May 2017. I'll direct you to, I'll direct the committee to MOJ 5A, Honorable Chair.
5A.
MOJ 5A. However, in your records, it is the Are you there, Honorable? Honorable Chair, is the committee on the same page? Honorable AG?
Yes.
I would kindly guide the committee on the issues brought out by the order. Specifically on the custodians of certain properties. Should I rephrase the question?
I think I understood the question. It's a long order. You see, it's about 15 paragraphs. Do I repeat read it for the committee or?
Not at all. Not at all. Nothing as tedious. If you could just explain to the committee what the order sought to do, what the rationale was.
This was an interim order, from which I believe a receiver was appointed. The first receiver was appointed through this court order. I think that was Augustus Trump. And a decision of various categories of assets, the court ordered for, in some cases, for certain institutions to take custody. I believe for livestock, for example, in paragraph 4, the court said that all livestock be held by or in the possession and control of the respondent and his servants, agents, hereby ceased pursuant to this order and are to be kept under the custody and control of the Gambia Livestock Marketing Agency. So through this court order, the livestock, so first is a seizure order. All the assets were seized, and then they were put in different hands. For example, the animals were meant to be placed in the hands of GMLA, that's the Gambia Livestock Marketing Agency, and the receiver was to take custody of some of the assets. It was meant to last 180 days, so that makes it interim. Unless it is extended, it will naturally lapse after 180 days.
To the best of your knowledge, Honorable AG, was this order extended?
I've not seen any record of extension. So I take it that after 180 days, this order lapsed naturally.
Oh, AG, as you mentioned, the order placed assets, certain assets at the palms of several institutions.
Yeah.
You had mentioned the institution Gambia Livestock Marketing Agency, GILMA, to be the custodian of the livestock, and Gambia Wildlife Services,
For wildlife, yeah.
and so forth. And particularly, if you look at paragraph 2,
Yeah.
the Registrar General
Mhm.
was also given custodian of several assets. Isn't that so?
Yes.
Can
Asset
you-
listed in annex. Yes.
Could you guide the committee as to what assets?
Paragraph 2 said the custody and control of all movable and immovable properties held by or in the possession or control of the respondent, his servants, agents, associates, and family members, or otherwise howsoever as listed in the annex marked 1, attached to this order, be and is hereby granted to the Registrar General. So pretty much that's a whole sum of assets, movable and immovable.
Honorable AG, can you confirm who the Registrar General at the time was? This is in May 2017. I do understand that I am putting you on the spot. If you cannot recall, you're more than welcome to submit it to the committee on a later date.
It's safer, since I am on the oath, it's safer I confirm and formally submit that.
So back to legal notice number 15 of 2017, MOJ 2, as per our list.
Yes.
It is understood that when you look at clause 1, clause 5, and clause 6, it is understood that the president has the prerogative of appointing commissioners as well as the secretary. As Attorney General, could you guide this honorable committee as to the considerations that are put when such appointments are made?
If specific qualifications are provided for, those will be taken into consideration. But generally, we look into issues of character and other competencies that make somebody fit and proper to discharge the duties for that position.
With reference to clause 6 of the legal notice, the same is applied for counsel to the commission, but in this instance, it is the prerogative of the Attorney General. Would you say the same considerations would apply, or are there additional considerations?
Again, yes, pretty much. Because this is counsel, of course, you will look for a legal practitioner. Yes, but the fit and proper test too will apply.
From the records of the ministry, did the government of the Gambia envision a need for oversight? And what is the propriety, if you could guide this honorable committee, what is the propriety of any oversight?
Oversight
from a government to the commission? Is it proper for an institution of government to be to play oversight on the commission?
Have the same understanding of oversight. I think that's where the issue will be. But Section 200 inquiries usually they are presidential in nature, because under Section 200 of the Constitution is the president that establishes commissions of inquiry. But from experience, they work through the Ministry of Justice. But that doesn't mean that no other ministry can supervise or walk through them. But the oversight, in my understanding here, because these commissions, once they're established, in my view, they are autonomous. But the commissions are there. You say some have to be made either by the president. If vacancies occur, there are administrative issues. Sometimes they may even need additional facilities, like the place they are supposed to operate from, vehicles, and so on and so forth. So with respect to that relationship with government, there must always be some form of a ministry or probably a department of government have to liaise with them. To what extent you consider oversight with them and what you mean by oversight, I don't know, but there is always going to be a contact ministry for the commissions. There are conclusions and there are reporting and recommendations.
So just to be clear, the relationship between the commission and any ministry is for the purpose of contact and perhaps to facilitate administrative endeavors.
Yes, to facilitate their work for them, yes. But with respect to their mandate, they are supposed to be fully autonomous.
With respect to the TOR of commissioners, the secretary, and the lead counsel, can you confirm that the authority of the commission is first of all explicit?
I don't know whether we're seeing eye to eye. It is the commission that is instituted. It is the commission that is given a mandate. Yes, the commission is made up of individual commissioners, but they function and discharge their mandate as a commission, not as individual commissioners.
The point is taken.
All right.
When we look at clause 2, and I would give you enough time, I would ask the Honorable Chair through the committee to
whether the commission had a mandate to. Well, that will regard me to go through the paragraphs. The commission is authorized to inquire into and investigate. So investigation is clear. That is part of their mandate. If you're looking for a specific paragraph, if you guide me, it's easier because this is the longest paragraph of the legal notice.
It is, and that's perhaps why I asked the committee to give the AG a bit of space.
So yes, they do investigate, ascertain bank policies, ascertain whether the withdrawn sums, identify institutions, persons, and groups, inquire into and investigate all involvement of the executive arm, including not limited to ascertain whether applicable policies and procedures were followed, ascertain whether funds and resources withdrawn applied, identify institutions and persons and groups of persons directly involved, inquiry into whether or to what extent also investigate the extent of the Okay, I can take specific questions now on clause 2. I think I've gone through it.
What, just to make it shorter, what powers, what authority is given to the commission?
Precisely investigate, make findings, and recommend to government.
Would you say the commission, I'm just putting it out there, Honorable AG, would you say the commission had the powers to prosecute or to adjudicate?
When you say prosecute, you mean criminal prosecution? Or prosecute civil cases?
Prosecute, yes.
Prosecute in general?
Yes, in general.
And before itself or before a court of law?
I would allow you to deliberate on that.
Now, as outside of this TOR, the commissions are set under the Constitution and they are vested with powers of the High Court with respect to compelling attendance of witnesses, production of documents, and also making interim orders. That's a constitutional provision. And they have mandate to implement that, which is outside. We would not find that in this legal notice. But that's a power that they have. So the way they utilize that, whether you call that prosecution or not, that's something else. But they have the powers of a court of law, High Court for that matter, with respect to compelling attendance of witnesses, production of documents, examining witnesses, and also making interim decisions.
Honorable AG, since you raised the issue of the Constitution, perhaps we could refer to Section 202 of the Constitution. Could you kindly guide the committee as to whether, having looked at Clause 2 and tallied it with 202 of the Constitution, especially 202.1, in your view?
No, I'll go to 202.2 if you have it.
Yes, but we would like context on 202.1 first, because
202.1 says the Commission of Inquiry shall make full and impartial investigation into the matter in respect of which the commission is established, and B, furnish in writing a report on the result of the inquiry, including statement of the reasons leading to the conclusions of the commission. My answer that I just gave before this question is related to 202.2.
I would allow you to deliberate.
So 202 says the Commission of Inquiry shall have all the powers, rights, and privileges of a judge of the High Court at a trial in respect of A, enforcing the attendance of witnesses and examining them on oath, affirmation, or otherwise; B, compelling the production of documents; C, issuing commission or request for examination of witnesses abroad, and making interim orders. Yes. 2021, the general powers of a commission of inquiry and or general mandate, which is to investigate matters, make a report, and give reasons for their conclusions. I would say 202 provides them the power to be able to discharge that function. Some authority, because for you to be able to discharge certain functions, you need some form of authority. That's the authority to invite witnesses. If they refuse, you compel them. The authority to compel production of documents. So they need to have those authorities for them to be able to do their job. So 202 vested them with authority in order to perform 2021.
So you then agree that 2021 is where the core function is?
Of any commission of inquiry set up under the Constitution.
Yes.
Those are the general.
Yes.
So the specifics may be contained in the legal notice that.
Indeed.
All right, yes. We agree on that.
And 2021, when looked at, highlights that the commission shall investigate, if I can just take the keywords, and report. Those are the two functions, to investigate and...
Yes, yes. Making interim order.
Yes. Yes. How would a commission of inquiry go about exemplifying such a...
Okay, counsel. Interim orders. We've seen an example issued by the court. The one that you referred to me here, MOJ 5A. I said here earlier, that's an interim order, but that is issued by a court, high court. So it's similar along those lines. Interim orders are kinds of orders that are made to last within a period of time. So if they are vested with the authority to do so, it may vary depending on the circumstances they are dealing with. But it's to make binding orders that are not meant to be perpetual, but are meant to last for a given period of time.
And those orders, are they in any way to be aligned to the functions of the commission for the establishing legal notice?
Come back on that again.
Let me rephrase. Are those orders to correlate with the legal notice establishing any given commission?
Whether the interim orders the commission of inquiry may issue whether they should be in line with their terms of reference? Yes, because to a great extent, yes, because the terms of reference serves as the framework within which they are meant to operate. So the orders must be linked to their mandate. I agree with that.
Thank you. When we look at this particular commission of inquiry, perhaps before that, Honorable AG, for the benefit of the committee, could you guide on the aim of an interim order? Of course, you had mentioned that an interim order is not to last in perpetuity. I mean, that is denoted from the name interim order. But what is the aim? Why do courts or commissions need such powers?
Mm-hmm. It's just to take care of a given situation they're facing with. So for me, that will differ on the exact situation they are trying to deal with. But these are powers that are vested in the courts and are vested. Sometimes they are used to remedy or mitigate an irreversible harm that may occur if such orders are not made. So, and you know, generally in the courts we call them injunctions in generally, and their main purpose is that to prevent a greater harm, so or restore or keep a status quo in place. So they may vary depending on the kind of order that is being granted.
So preservation is definitely key among
preservation of a status quo, prevention of certain harm that may arise, and this is a situation where you cannot wait for the whole process to play out. So you need to take a decision at the moment now to take care of it now, because it is a situation that could not wait for a longer period to prevail. So it varies from one situation to another, but mainly broadly, these are some of the reasons.
And I can appreciate that it may vary from one situation to the other. At any given period, would disposal also be within the realm of your answer?
Disposal of assets.
Indeed.
This is a very broad power. I have to put it that way. It's a broad power, and the power did not limit it. So long as the order is relevant to the mandate of what the commission is meant to be set up for, I wouldn't have any issues with it. But unless we are specific, I don't want to make a general answer to say yes or no, because it may vary depending on the situation that the commission was facing at a given time.
I'm satisfied with that. If the Honorable Chair is, I would then move on to the appointment of personnel of the commission.
Thank you.
Honorable AG, when it comes to appointment, is there ordinarily a role that your ministry would play in advising the government, the president, to be specific, in appointing a commissioner and the secretary?
For this particular commission, I don't know, but the commissions that are created while I'm in office, usually this will be limited to legal practitioners who might serve either in the commission itself or serve as counsel. Because different expertise are needed, both at the commission level or at the secretariat. So there are certain staff that are to be appointed at the secretariat level. Based on my experience, I have never advised on other staff. But where legal competencies are required, yes, I'm consulted to advise. But I don't know in this specific committee how the appointments happen.
Perhaps if we can draw reference from the commissions that you have set up, just to guide the committee, would it be appropriate for the Attorney General to put in a word or two in advice as to personnel who will form up of the commissioners and the secretary? Since usually the commissioners of inquiry have a legal face, if I can put it that way.
Yeah, they are quasi-judicial. I'm wrong with it, because any minister is the president on any subject if the president requires your advice.
And of course, you have confirmed that when it comes to the legal practitioner or counsel, the Attorney General would indeed advise. Now, I can appreciate that you had previously given an answer that there is a criteria, but could you guide this committee as to specifics that the Attorney General would look at in appointing any of these individuals? I do appreciate that. Yeah, it mostly applies to lead counsel. However, if you could just shed light.
So for chairpersons of commissions of inquiry, the qualification is stated in, I think, 200. Is it? Yes. Yeah, 201 to but thereabout. So for chairperson, the qualifications are in the Constitution. If it is a Section 200 Constitution, the chairperson's qualification is stated that it must be a person who was either a High Court judge or is qualified to be appointed a High Court judge. So that one is in the Constitution. I think we also have a Commission of Inquiry Act. Either there or one of the legislations, I couldn't accurately recall which legislation, which also states that other commission members should at least have some competence or experience in the subject matter, or let's say the mandate of the commission, because every commission is set up to look at something. So it is desirable that other than the chair, other members that are to be identified have some form of competence or experience in the subject matter of the inquiry. Yeah. Yeah. So those are some of the guiding principles we apply.
Thank you, Honorable Attorney General. In applying those guiding principles, is there any requirement for filtering through conflicts of interest? Now, to put context to it, I can appreciate that the TOR, sorry, let me refer to it as the mandate of the commission per clause 2 would have been drafted prior to the appointment of commissioners, lead counsel, and secretary.
Ideally, yes.
Ideally, yes. So, with that in mind, are there any protocols put in place to filter through conflicts of interest and whatnot, in your view?
Every such appointment should look into the issue of conflict of interest, yes.
Thank you. Now, we've clarified that, or rather you have clarified that the commissioners act as a union, and they act per clause 2. Was, however, the secretary given a TOR?
On top of my head, I can say his appointment letter should outline his task. But I also will have to confirm, my team is here with me, the Commission of Inquiry Act made mention of a secretary. I'm not too sure whether it went into detail what the function of a secretary should be. So we can, but we can also look at whoever was secretary, their appointment letters are supposed to say something about their job. But because they are also staff of commission, they are also answerable to the commission, so the commission can also give them further directives.
Right. Honorable Chair, I would ask for MOJ 7.
Okay, good.
And refer the committee to MOJ 7, which is the appointment letter for the first secretary. And while we turn to MOJ 7, perhaps Honorable AG. My apologies. MOJ 3E.
Oh, okay.
3E. Perhaps before we zero into MOJ 3E, which for the record is the appointment of the secretary, Alhaji Mamadi Kurang. Honorable AG, could you guide the committee as to which body, whether the ministry, the government, or the commission, is the appropriate body to issue a TOR for the secretary, or could it be both?
I'll still want to refer back to the Commission of Inquiry Act.
If I can, just for expediency,
Yes.
to section 6 of that act.
May I borrow it because I'm trying to locate mine?
Yes, if I could ask the Secretariat to facilitate. It is chapter 30. Chapter 30 should be in the first few, either one or two. Chapter 30, Honorable. Indeed, it is volume 5.
Can you refresh me with your question again about the secretary?
So the question was whether the secretary was given a TOR, and you had alluded to the fact that perhaps it could be entailed in
Yes.
a letter, his
Which
letter of
I
appointment.
looked at. I don't think it's very helpful.
Can you confirm?
So in the appointment letter of the first secretary, he was directed to familiarize himself with the commission's terms of reference. But the letter itself did not specify terms of reference. So that's why I'm trying to locate. That's volume 5. Thank you, madam. Right.
Sure. As you flip through the pages of volume 5, could I expressly read the paragraph you're referring to?
Yes, please.
Honorable,
That's
I would read it for
yes, please.
for you, Honorable AG. The paragraph says, this is the third paragraph in the appointment letter. It says, kindly familiarize yourself with the Commission's terms of reference and your attached TOR, which will be terms of reference, as a guide to your work.
So, yeah, Section 6 of the Commission of Inquiry Act says the President may appoint a secretary to attend the sittings of the Commission, to record their proceedings, to keep their papers, to summon witnesses, and minute their testimony, and generally to perform such duties connected with the inquiry as the Commissioners shall prescribe. So, that's a legislative function of any secretary of any Commission of Inquiry.
So, Honorable AG, could we comfortably say that that would be the TOR of the secretary?
Yes, it's a mandate of a secretary, general one, and then the rest, I think the details will be if a specific commission of inquiry, because the secretary is a staff of the commission, so the commission can give further directives to him on other issues. But generally, this is to attend meetings, record the minutes, be in custody of their documents and other properties, and so on and so forth. Yeah.
So the appointment of the secretary, which was also done on the same date of establishing of the commission, that is the 12th day of July 2017, it alludes to a TOR attached to the letter. If the Honorable Chair, can your ministry confirm whether such attachments are in your possession?
My staff just informed me. I think part of the documents that were requested, this is one document we searched, we couldn't find. We saw the letter, but we didn't see the attachment of the TOR. I can assure we will keep looking. We'll keep looking. If we find it out at any point in time, we will happily say.
Honorable Chair, I'm comfortable with that answer. I would move on. Can we look at the TOR of the lead counsel? And before we delve into the issues of the TOR, perhaps we can equally look at lead counsel's appointment letter.
That is MOJ what?
Which is MOJ 3B.
B. Yes, I've seen that.
Again, we don't get much solace from the letter.
Actually, this one did not even mention the TOR.
Indeed.
It just asks the lead counsel to familiarize with the work, with the terms of reference of the commission.
In your view, Honorable AG,
yes,
who would be responsible for issuing these terms of reference for the lead counsel? Would it be your ministry or would it be the commission?
You mean terms of reference for the lead counsel?
Yes.
I'm not sure whether traditionally this has been done. I've not seen one myself throughout. Terms of reference for the lead counsel. I'm not sure whether you have got one in the assembly here. You know, but I've not seen one. I've appointed counsels counsels to go and be lead counsels in a commission. But to be honest with you, I have to be honest, I don't remember doing a terms of reference for the lead counsel. So it didn't occur to me if it should happen, who should do it. But naturally, the appointing authority always should give the terms of reference.
And the appointing authority is the Ministry of...
Yes.
I would refer the committee and your humble self, Honorable AG, to MOJ 3K. It's a letter dated the 24th of July 2017. It's addressed to the Attorney General. The letterhead on the letter emanates from the law practice of Ami Bensouda and Co.
$3K, yes. Okay.
The letter is also signed by lead counsel. And I believe lead counsel was prudent enough to allow for a space within which the Ministry of Justice would acknowledge and agree to the contents of MOJ 3K. Now, for the benefit of the record, Honorable Chair, MOJ 3K is an engagement issued from lead counsel to the ministry. Can you confirm that, Honorable?
Yes. These have now shed more light to the arrangement. Engagement letters are typical way or ways of engaging services of counsel who are in private practice. So it's normal. So they write back to the instructing or employing or the client per se. We call it the client, and outline the terms of engagement. If they are agreeable to the client also signs. So it becomes the contract between. And I can understand in this situation because the lead counsel wasn't a staff of the Ministry of Justice that is posted to the commission. Is a private practitioner that is being engaged to do this job. It's perfectly normal that the engagement is done through an engagement letter. So the ministry would have discussed the terms, so we would consider this to be the agreed terms, so they both signs. So that defines the relationship between the lead counsel and the ministry.
Well, AG, I am happy that you have outlined that this is more this, yes, legal practice.
Yes.
However, is it normal practice in public service with your experience?
It's normal practice in hiring the services of lawyers who are in private practice, because up to today, as we speak, Ministry of Justice do hire private practitioners to do some jobs, locally or abroad. And when we engage law firms, we engage them through engagement letters. So yes, and that is done within public services. I have hired lawyers myself through engagement letters.
And who issues the engagement letter? Is it the ministry?
It is it's always the lawyer that you are hiring that sends the engagement letter, and the client. Because even though we are a ministry of lawyers, if we hire a lawyer outside, we are a client. To that lawyer, we are a client. And because we are representing the Gambia government, because they're going to be doing work for Gambia government, so Gambia government is the client, but of course the Ministry of Justice is one acting for government. So they see us as client. And in law practice, it is the lawyer that proposes letter of engagement to the client reads it. If it is agreeable, you sign, then it defines the contract between you and the lawyer.
That's understood, and I believe that is quite reasonable.
Yes.
I would like that you comment
how that relates to the commission.
Perhaps not. If I could give you
yes, go ahead.
Some context, Honorable AG. to my mind and to the mind of the committee, when a lawyer engages a client, the client is believed to be a layperson, usually not so well versed in law. And as a consequence, the lawyer would detail out the scope of the work to be done so as to avoid ambiguity. In this case, however, the instructing authority, or the client, if I can put it that way, is equally a chamber of legal practitioners. And to be quite exact, the chamber, the leader of the bar, seeing that it's a government initiative to establish a commission of inquiry, detail out its authority, wouldn't it equally have been reasonable for it to be a government initiative to engage counsel and detail out what the scope of counsel's work is?
Yeah, so for me, it's like it's a contract. So maybe we're looking at who drafted the contract or who proposed the terms. But once the ministry reviewed it and agreed to it and sign off on it, for me, whether it was proposed by the lawyer or proposed by the ministry, the most important thing is, were the terms favorable to government? Do you have issues with the terms? But other than that, for me, if they both signed it, their eyes open, I am not very much bothered as to where it comes from. It could have come from the ministry, but equally, like I said, it's normal in hiring private practitioners that the proposed contract comes from the lawyers. And the fact that because we are a Ministry of Justice, that is to say, a ministry full of lawyers, doesn't change that practice. You would agree with me that certain practices are just the norm. So the norm is the lawyer you are hiring proposes the terms of the engagement, and you, the client, reads it. If you're agreeable, you sign. If you're not agreeable, then you further negotiate until you agree on terms, then you sign off.
Thank you, Honorable AG. Just to be very clear, and for the purpose of just guiding the committee,
Sure.
it is immaterial who proposes the terms of reference, as you have mentioned, as long as both parties agree. Is that your position?
Yes, but it's also not out of place. I still emphasize that's the custom in our trade. It's usually the lawyer you are hiring that proposes the terms.
Thank you. Moving on to the human resource of the commission. With the records that are available to you, have you deciphered how the commission equipped itself with regards to human resource? So the core staff of the commission.
No, I did not take time to look into that. We provided documents that are as much as we can see. Well, other than the lead counsel and the secretary, how other staff are either recruited or posted there, no, I've not looked into that aspect.
I can appreciate that you have not looked into that, but to the best of your knowledge, do you know whether any personnel were obtained from other institutions? I mean, it is only natural to do so.
I hear like anybody else that some police officers were there. I don't know, to help with investigation. Remember, they are investigators. I also had some Ministry of Justice lawyers too were at the commission. I've seen some of them whom I know already. So, but really, how they got there, whether they went on secondment, whether they were recruited, how they got there, I don't know. I don't know how other staff got to find their way at the commission.
With respect, Honorable AG, I'm trying to be as delicate as possible. I would not be satisfied with that answer, that you heard that such and such a person was in the commission. If the committee would permit you to consult with your team, we'd want a definite answer on this. Either you don't know, or that the records reflect that personnel were hired or seconded from other institutions.
I don't know. If there is any record you can refer me to, I'm more than happy to examine it. If it is a document of the ministry, I can comment on it. But I don't have, I really don't know how the commission recruited its staff.
Indeed. I would refer you to MOJ 3F.
Okay.
There are several
3F.
3F. Please also look at MOJ 3N.
3F. 3F is the letter dated 14th of August 2017.
Indeed.
And then 3N, you say 3 what? N?
3N, yes. 3N is dated the 12th day of July 2017. I can also refer you to MOJ 3P1.
I've got N. P1.
Yes, P1. There are several documents. You can stop at N if.
Okay, so I have got F and N.
There's also MOJ 3P1 if you would like to look at it.
3P1.
Well, the whole P series, MOJ 3P 1 to I believe 7.
Okay. All right. So I've got all, I've seen all of them, yes.
Should I repeat the earlier question, since you have the benefit of record now?
Yes, sure.
Were any personnel obtained from other institutions?
Yes, from the exhibits we can see here, yes. I've seen a letter from the 3F is a letter from the Ministry of Justice addressed to the Judicial Secretary, request for a court clerk on secondment to the Commission of Inquiry. 3N is a letter from the Ministry of Justice, again to the Judicial Secretary, request for secondment of judiciary staff to the Commission. And the P series also, letter from Ministry of Justice again to Judiciary, request for deployment of additional 2 transcribers. P2 requests deployment to the Commission of Inquiries. So, yeah. And then P3, again, later from Aegis Chambers to the Judiciary, request for additional court transcribers. P4, the same. No, this is response from Office of Chief Justice to nominate a particular transcriber. So, yeah, now with this documentary evidence I've seen, yes, I've seen these are evidence of requests made by the Ministry of Justice, at least to Judiciary. Probably maybe similar requests are made to other institutions to second staff to the Commission of Inquiry.
And you would agree with me, Honorable AG, that it is quite normal for staff to be injected to the Commission from other already established departments. Could you guide the committee on why this is crucial or why this is necessary?
I mean, the commission is not a permanent institution. It is created, but by its nature, it is ad hoc. It is just given a task to perform, discharge its duties, and then dissolve. Now, in that regard, usually, they are supported. by the required resources that they need. So they don't go into long-term contracts of employment and things like that. So it's perfectly normal. Government institutions that have those capabilities, like the police, to attach investigators to them, make them at their disposal, court transcribers to be there to help them to transcribe their record of proceedings. You send clerks, court clerks there who are experienced with filings and to help them deal with their filing works, and also maybe attach accountants there, Ministry of Justice attaching lawyers there to support the legal team. So within the government, it's perfectly okay that where the capacities exist in various departments, some personnel are attached to the Commission of Inquiry, pretty much like a secondment or posting or attachment for them to go and support the commission to discharge their responsibility. So this is okay. It's perfectly okay. I can even refer the commission to Section 15 of the Commission of Inquiry Act, where a similar provision is there for the police. He said the president may direct the Inspector General of Police to detail police officers to attend any commissioners appointed under this act to preserve order during the proceedings of the commission, to serve summonses on witnesses, and to perform such other duties as the commissioners shall direct. So this is specifically for the police, but the same principle applies to other institutions that have capacities that the commission may require for them to be able to do their job.
Thank you, Honorable AG. These persons who are moved through the commission, how are they remunerated?
The one that I'm aware of, I think they get an additional allowance for the period that they will be attached to from the commission. So that's budgeted within the commission's budget.
So their salaries then come from the commission? Or, sorry,
No,
their allowances?
not
rather.
salaries, no.
Allowances,
They continue to remain employees wherever they came from, and they will continue to get their normal salaries there. They just get top up for the assignment that they are undertaking.
And for the purpose of reporting within that period, who do those such employees?
To the commission.
To the commission.
To the commission.
Exclusive.
Yeah, they are completely detached from their department. For that period, they are answerable to the commission.
When you say detached, do you mean physically or just with respect to reporting lines?
Physically, they report to the commission when they get up in the morning, and they work with the commission until the assignment is over. The lawyers I attach to the current ongoing commission, I don't see them. They don't come to Ministry of Justice. When they wake up, they report to the commission. And until that assignment is completed, I don't give them any instructions.
And Honorable AG, it would be strange for you to give them instructions, wouldn't it? During the pendency of the commission.
With respect to the commission.
Anything in respect to
the commission. Yes, unless if I need them something separate that has nothing to do with the commission, recall them maybe for a particular thing. Yes, but with respect to their work at the commission, they are answerable to the commission, not me.
And you confirm that it would be strange or inappropriate, if I can.
I don't want to be adjectival. But yes, I don't give instructions, and because the law is clear, once you attach them there, they are answerable to the commission.
So the personnel who formed up the staff of the commission were not only public servants. Inherently, lead counsel was not a public servant. Were there other such personnel who were not public servants but were part of the commission as staff?
I really wouldn't know. I wouldn't know. But I know public servants are do attached there. Whether they have hired some staff who are not part of the public. Remember, the commissions do have their budget and they have the capacity to hire expertise. Yes. So the government postings are meant to maybe ease those capacity challenges, but nothing stops them from recruiting people directly into the commission.
When it comes to the team that supported counsel, lead counsel in the commission, who hired or who engaged rather the services of?
In this respect, I don't know, except if I can go through the record. I didn't avert my mind to that before coming here.
With respect to MOJ, MOJ 3K,
3K.
perhaps if the committee could afford the Honorable Minister a moment or two to just peruse MOJ 3K before I pose the question.
Okay, 3K, that's the date of engagement. Yes?
You want a moment to look at the content of MOJ 3K before I pose my question?
Okay.
With regards to MOJ 3K, is it so that it was an individual that was engaged or a firm of legal practitioners that was engaged? Can you please clarify?
Based on my perusal, I formed the opinion that it was the individual that was hired, not the firm.
Thank you. Honorable AG, I would refer you to paragraph 3 of MOJ 3K, the letter. On the tail end of paragraph 3. It's the third page of the letter, just before the word team. Now, I must apologize. It's a bit of it's a paragraph before team, and I do acknowledge that I am asking the leader of the bar to read this very long statement. But could you kindly read this statement for the committee?
Oh, don't worry about that. I'm here as a witness, nothing more. Our lawyer-client relationship with, and sorry, our lawyer is blurred though, the printing is not very clear. But it says our lawyer-client relationships.
Perhaps if we could furnish you with
a cleaner
version.
Okay.
Version, yes.
Okay. Oh, it's much better. Our lawyer-client relationships with and our duty of care is owed to your office only and is limited to matters relating to the commission. All advice provided by us is for the benefit of your office only. Unless we agree otherwise in writing, our advice does not extend to and may not be relied upon by third parties, including other government departments.
Honorable AG, if you could continue to the under captioned after team.
In addition to the investigators and the 2 assisting state counsel from the Attorney General's chambers, Ms. Ananjai, a senior associate of my firm, will assist me in the commission at no extra cost.
So just to circle back on the record, you had earlier mentioned that this engagement letter, being the normal practice, was agreed to by the government. So in essence, the government agreed to personnel from the firm of legal practitioners named Ami Bensouda and Co. To be part and parcel of the commission, correct?
Yes.
Thank you. We would I would like you to guide the committee as to whether this is ordinary practice, whether there is anything out of the ordinary in such a practice.
Well, if you hire a lawyer that operates from a firm, if you agree that any member of that firm, because if you hire that lawyer in his or her individual capacity, and he offers that, okay, I know this contract is personal for me, but a member of my firm will be supporting me, and sought your permission and you agree to it, I don't see anything out of the ordinary in that.
Thank you. To circle back on the record furthermore, on the issue of specifications before appointment, would the same due diligence in appointment also apply to whoever is brought by counsel?
Yes, that one I agree. Anybody that will be working within the assignment, probably that's the reason why, well, not speculate, but yes, the same amount of due diligence will have to apply, whether the person is going to be working for a fee or voluntary. As long as the person is going to be working on this assignment, the same amount of due diligence need to be applied.
To the best of your knowledge, was that done?
I don't know.
Perhaps Honorable Chair, we can allow the AG to serve the records.
If the due diligence was done and is, like I said earlier, is memorialized, there's a recorded evidence of due diligence, if we find it so, we will provide it. But whether the due diligence was done and a report is generated, I don't know. But we will check. The team is here. They're taking note of all these gaps. And if they do exist, we will provide them.
Thank you, Honorable AG.
Thank you. What we do is we can request from the AG if those documents are available as well. We can.
Sure. So, because due diligence can take many forms, but I don't want to speak for those who were meant to do the due diligence. My role here is to find out whether I'll come across any record of due diligence done. If I do find a record of it, I'll provide it.
Now, Honorable Chair.
If I don't see it, I wouldn't say due diligence was not done. My answer to you will be I couldn't find any written evidence of a due diligence. Yes.
Thank you, Honorable AG. Honorable Chair, if I could refer the committee to MOA 3R 1 and 2, as well as the Honorable Attorney General. R. Honorable Chair, members, have you traced the document? It's a letter, MOJ 3R1 is a letter dated the 5th of November, 2018. And the subsequent one, 3R2, is a letter dated the 6th of November, 2018. Honorable AG, are we?
Yes, please, yes.
Did you?
So I've seen R1 and R2, yes.
Going back to, have you had the benefit of perusing?
Yes, I've perused them, yes.
Going back to your answer, the ministry, for example, are assigned to the commission. They are physically and they are detached from the ministry, physically and in authority.
Yes.
With the benefit of MOJR, the comment.
No. MOJ 3R1 is a confirmation request from the Commission of Inquiry addressed to the Ministry of Justice, to the Solicitor General, inquiring whether 3 named staff are actually staff members of the Jane Commission of Inquiry. So it is the Commission of Inquiry asking the Ministry of Justice, with 3 names mentioned in the letter, asking the Ministry of Justice to confirm whether these 3 named individuals are actually part of our staff, if I put it that way. The Commission asking the Ministry whether these 3, can you confirm whether these 3 are actually part of our staff? And the MOG 3R2 is a reply from the Ministry of Justice actually confirming that yes, these staff, are because they have been working on the activities or affairs of the Commission.
Honorable,
yeah, so the reply said in their first substantive paragraph, says, kindly be informed that since the inception of the Commission of Inquiry, the 3 staff have been part and parcel of the operations of the Commission in addition to their daily duties at the Ministry. So I could deduce that they may be based at the Ministry, but they are doing the work of the Commission of Inquiry. How they did that, I don't know, but that's what I can deduce from here. Because if you see the Commission of Inquiry is writing to ask, maybe they were not physically with them. So, but the ministry now confirm, yes, they have been involved in your operations in addition to their work with us here at the ministry. That's what the reply is saying.
Don't you find that strange that the ministry, rather the commission, having been assigned 3 personnel from the ministry, are not aware or are uncertain as to the appointment or operations of, and it would take a person other than the commission to clarify that indeed those persons are working with the commission?
I want to remain a witness of fact. I think that's for the committee to look in and decide a conclusion. But factually, there was an inquiry, there was a response, and my deduction of the facts shows that probably they were in the ministry, and the ministry confirms that in addition to their work in the ministry, they have been involved in the operations of the commission. I want to leave it at that.
Honorable Chair, I would not belabor the point. I would ask that the chair, the committee refer to the earlier answers given by the Honorable AG and tally them with the revelations as per 3R1 and 3R2. And I would move on. Good. Just to circle back on an issue, just out of the abundance of caution, ordinarily, who would be responsible for detailing the TOR of other council, not the lead council, but other council, subordinate to lead council?
You see, this TOR issue for council, okay, we've seen this unique practice here where a letter of engagement have been agreed upon, which is very broad and detailed. So if we take that to be the TOR of the lead council with respect to Janneh Commission, I assume then any other council attached to her will just fall in. They are all bound by the same TOR. If it is a different arrangement where a lead council probably has a, because for me, the TOR that defines the lead council's mandate, any supporting council, the same TOR will apply. I cannot see in my head how you can have a separate TOR for the same legal team. You will have one for them, and all the team members will have to operate within the same TOR. That's how I see it.
Indeed, Honorable AG, that would seem reasonable.
Yeah,
I would agree with you. However, when we look at MOJ 3K, which is the letter of engagement,
3K, the letter of engagement.
Yes. 3K,
okay. Yes.
The letter of
yes.
It accounts for lead counsel and her accompaniment. And the committee has observed that indeed there were counsel referred to the committee or appointed to the commission rather from your ministry.
Yes. But they are described as assisting counsel. If you look at team, said in addition to the investigators and the 2 assisting state counsel. So that means they were posted to assist the lead counsel. So they can only assist her in discharging her mandate, not under a different mandate.
I'm grateful.
Yeah.
Good. Moving on to the relationship between the ministry and the commission. Can you please reiterate what the usual practice would be. Would it be a practice of, I believe you had mentioned contact person. Can you dilute a bit more on that? Contact person, or would it be a relationship of, I had previously mentioned oversight, and you had contended with that word. Just, I would like you to further elaborate on that point, the relationship between the Commission and the MOJ.
So I actually have not disagreed with oversight. My concern was whether my understanding of oversight will be the same as yours. But you can call it oversight, you can call it the liaison department, whatever description you want to give it. But from my experience, we are responsible of communications between them and government, communications in general. And these communications usually borders on budget, logistics, personnel, those kind of issues. Because from my experience, once the commissions are set up and there are legal notices or their TORs being published in a legal notice, government doesn't interfere with their discharge of their mandate. But of course, they have issues of personnel, they will have issues of budget. This we deal with through them. And the entry point becomes that ministry that you could call an oversight ministry or the liaison ministry.
Thank you,
Yeah.
Honorable AG. In fact, the MOJ was the mouthpiece of the government in relation to the Commission. Wouldn't you agree?
Yes, because we see this commission as part of the broader transitional justice process. And the Ministry of Justice is in charge of transitional justice.
Indeed. Yeah. From the records, and of course, we would give you the benefit of consulting with your able team. How often and how regular were the contact from MOJ, between the MOJ and the Commission?
How often and how regular?
Yes, and what were the nature of the contact, the regularity of it?
I have found this commission disbanded long time ago. So I cannot attest to that. And the number of contacts they have, how often and what subjects, I don't think that will be found on record. Because some of these contacts could be informal meetings, it could be telephone calls, it could be various ways of contact. So probably it's only the officers that were in office at the time that can confirm that.
So would it be normal for contact to be made through telephone calls?
Of course, yes.
When
I came in, the TRRC was still sitting, and I have all forms of contacts with them. You see, it depends on what subject matter you are contacting on. But contact is not bad, because you are working with them day to day. When they have budget issues, they can call the AG and say, look, our this month's allocation is not coming. Why don't you help us with Minister of Finance? So you can have telephone. Sometimes it could be so serious that they walk into your office and they have a serious situation that you need to look into that directly affects their operation. So the contacts continues, and it can be in many forms over different subjects. So the contact is not the problem. What are you having contact over? I think that's the issue.
Indeed, Honorable AJ, and the committee would agree with you, and this is precisely why we pose the question to you, to be able to guide the committee on
so general answer is contacts are regular, are normal, because it's an ongoing thing. But I cannot speak to contacts that were done when I was not in office. I don't know the nature of the contact, how often were they, what issues brought them together. I don't know that. But during my time, the commissions that I serve as an oversight, borrowing your term, yes, contacts are regular. They are normal. Sometimes, in fact, typical situation could be sometimes their mandate expires. They need an extension because legal notices are time bound. You would see, I think Jane Commission was originally meant to be 3 months. And it went longer than that. That's a typical operational issue. They have to come to the Justice Ministry to negotiate and talk about how long more time do they need for extension. I have extended the mandate of the TRRC, I think, once, twice or so. So there are so many reasons why commissions of inquiries will have contact with the ministry. So many reasons.
Honorable AG, were there, from the record once again, right? Were there any communications from the executive seeking updates, access to information or attempting to look at the direction of the commission's trajectory?
I need to look
In
into
your,
that. We need to
would
look
you
at
want
that.
to
Yes,
consult
yes,
with
we
your
will
team?
take note of it, yes. To establish whether there has been a communication from the executive to the ministry, wanting
Yes.
to know
Any updates, information, or look at the trajectory of the commission?
all right, we will see whether we'll find any evidence of that.
Perhaps while you're at it, we can look at any communications from the executive that affect the commission and
Okay.
communicated directly.
So we take
to
it
the
that
commission.
as that's what you are interested in looking at.
Indeed.
Okay.
We dealt with the issue of human resource, and it has been established that it is normal to source personnel from different institutions. What about other resources such as pens, vehicles, laptops that the commission utilized? From the record, do you know how the government sourced?
Again, I would
items?
appreciate if there is a record of it that has been seen that I'm referred to. I have not got all this record on top of my head, but it wouldn't, on top of my head, it wouldn't be out of the ordinary if they are supported with material resources as well, just as the way they are supported with human resources.
It's interesting that you mentioned that communications can ensue between the commission and the MOJ, even on phone. And I can appreciate when a government apparatus has a difficulty in finances, budgeting, that they could call to follow up a prior correspondence.
Yes.
For the benefit of the committee, can you elaborate on how the commission was set up? Was it set up as a budget entity on its own? Or was it a line budget under the MOJ? Was it by subvention? How was it created administratively and in budgetary terms?
No, I don't know, because when I came in, they no longer exist under the Ministry of Justice. But for TRRC that I know of, and not sure whether I've got another commission. Usually, their allocations come under the ministry. That serves as an oversight, and so it comes in the form of a subvention. Usually, independent budget entities have to be permanent in nature, because that requires you being a budget line being created for you by the National Assembly in the national budget. No, but it comes usually under the ministry that is serving as an oversight. So we just receive in transit, and then you forward it to them.
Could you also guide the committee operationally? How do you account for what the commission requires? Are they required to detail out a work plan, to suggest a budget, or is it done for them by the MOJ?
No, they are autonomous in their finances. They develop their own budget. The commission approves it. Of course, there are certain items that require, I believe, minister's approval or probably the president, like the remuneration of commissioners and certain key staff like the secretary and lead counsel. Those ones, once they are approved, then they are part of it. Other operational expenses, I think they do develop a budget. And because they are autonomous, they are also audited.
So, Honorable AG, you had earlier mentioned that it is usual for other resources to also be sourced from other institutions, just like human resource would. And I appreciate that this particular commission that we're looking at, which is informally known as the Jane Commission, was administratively under the MOJ. However, are you aware of any other institutions or departments providing financial or other resources to the commission?
No, unless I'm confronted with a record of it.
And how did the ministry...
Because the reason why some of these things I'm saying no, because I do not have the institutional memory. I wasn't there. If I had the institutional memory, some of these questions I could answer them on top of my head. I do not have I have zero institutional memory of some of these questions you're asking because I was just not there. Even if I am spiritual, you cannot just know something that happened when you were not there. So because I have zero institutional memory, I don't know will be a lot of answers I'll be giving you unless we can find a document that spoke to that issue, that speaks to that issue, then we can all reference the document. So really, I don't know. But if there's evidentiary material to that effect, we can look at it.
Okay, perhaps we can allow that once your team has retreated, they can look through those, and any answers that are in doubt can be clarified by your team. But just to give refer the committee to MOU 4A and
4A. Emoji 4,
4A, 4B, and 4C.
I saw 4C, but I couldn't see 4A. And I saw 4D.
I would ask, Honorable Chair, that we give the Attorney General a bit of time to peruse these 4 exhibits.
I couldn't see 4A, but I've seen 4C. I've seen 4D.
So it's A, B, and C. 4A, B, and C.
I didn't see the A. If they are supposed to be next to each other, the A is not there. Sorry?
Perhaps the labeling has faded, but they're indeed there. But Honorable AG, I would be able to assist you with a copy of A.
Are they consecutive? Are they following each other back to back? So the 4A, where can I find the 4A? I've seen the 4C and D. After 3, I think this one I'm using, the binding may have a problem. Okay. All right. So there is a 4A, 4B. And again, with this one, 2C is not there, but I have C in this other one. So I think there's a problem with the binding.
So just to go through the exhibits,
Yes.
MOJ 4A
Mm-hmm.
is a letter from the Attorney General's chambers
Mm-hmm.
to the office of the President, and I do take note of the date,
Mm-hmm.
which is the date of the establishment of the commission.
Mm-hmm.
Could you kindly just guide us through this and perhaps any rationale to this administratively? The question, I assure you, is very innocent, and we just wish to get some facts.
Well, what I can say to this is a request to the Secretary General requesting for deployment of 5 vehicles, if I can see it right, to the Commission for a period of 3 months. That was the originally intended period of the Commission. This is perfectly okay because in government we have a centralized vehicle control system, which is under the Office of the President. So it's perfectly normal when departments are undertaking activities that would require vehicles that is beyond their capacity. They don't have that number of vehicles. It's a pool system, if I say it that way. So it's perfectly okay for government departments to write to the Secretary General and request for vehicles to be allocated to them, government vehicles for certain activities. So that, to me, this is very okay. So a commission is being set up. Instead of buying brand new vehicles for them, you just tap from the government pool of vehicles. So that's what they are doing here. They are asking for 5 vehicles to be attached or allocated to the commission for 3 months.
Thank you, Honorable AG. We would proceed to MOJ 4B.
Yes.
Which is addressed to the Managing Director of Gumpost.
Seeking for the post office box.
Indeed, and it's dated the 4th day of August 2017, just a little after, rather 14th day of August 2017, just a little after the establishment of the commission.
Yes.
Can you kindly do the same for this?
Well, yeah,
just
it's a given. It's just for correspondence.
Right. So it's the correspondence from the MOJ to the MD of Gumpost, right?
Yes. Yes.
When we look at MOJ 4C.
4C, yes.
Again, the party writing the correspondence is again the Ministry of Justice. This time addressed to the Judicial Secretary at the time.
Yes.
It is dated the 4th of October 2017. And it's seeking for 4 additional laptops for 4 transcribers, apparently, who were proceeded without their laptops, perhaps. Could you kindly explain, as you have explained the other 2? The committee would like to appreciate the administrative and logistical gesticulations.
It just come to the same. I mean, but in this case, these are personnel deployed by judiciary, probably without their tools. And now maybe they are writing to judiciary to say, please avail them their tools so that they can be able to discharge their mandate quickly and efficiently. Because a transcriber without a laptop, I don't know how would the transcriber function.
So the commission did not have to procure certain working tools. Is that what we are?
No, I wouldn't say that. I don't know the adequacy of their budget, but it's normal that they have their budgets. But whether these are cost-saving things, I don't know. I don't know how adequate their budget was, really. But it's normal that they do have their budget. But I cannot speak to why didn't they procure laptops. Instead, they are relying on institutions who posted their personnel to provide them their operating tools.
Honorable Chair, I am quite satisfied with the answer. However, out of the abundance of caution, if the Honorable AG can go back with his team and just give us a more detailed answer with more clarity, if that is possible.
What are you trying to elicit?
The reasons why we are trying to look into the administration of the setup and administration of the commission.
Yes.
We can appreciate that the motion establishing this committee goes on to the tail end, the findings really. But in order to appreciate the findings, the committee would like to get a good account of how the commission was set up and how it was structured to run.
Yeah, if you read this letter in detail, you will see that Ministry of Justice is telling the judiciary that the commission is working under a very tight deadline. They have a three months mandate, and the transcribers are behind schedule in making the transcribed proceedings available to the commissioners. As a result, in order to mitigate this, they're asking the judiciary, can you kindly provide these transcribers with laptops? So your question is, why didn't the commission, if they have their own budget, buy the laptops and have to rely on judiciary to provide the transcriber laptops? Really, I don't know. I'm not too sure whether that requires any further consultation. I cannot just speak to that fact.
I'll move on, Honorable Chair. Honorable AGI, looking at MOJ 4A, 4B, and 4C, all the correspondences were made, with the exception of MOJ 4A. The other two were made at a time when the commission was already set up. And this is, mind you, meant to be a body that is autonomous in their operations. And when I say operations, both the commissioners and the administration, because it is headed by a secretary. Do you find it strange that all their bidding is done by the Ministry of Justice? Can you guide the committee on this?
No, that is not out of the ordinary. Like I tried to explain earlier, their autonomy is with respect to their mandate, their discharge of their mandate. They are not autonomous in terms of resources. They always run to the ministry asking for resources A or B or C, and the ministry always goes to find resources to help them to do their job. Their autonomy, as per my understanding, is respect to their investigation, how they analyze their evidence, how they write their report, and the recommendations that they make. Their core mandate. But their autonomy doesn't get to the issue of resources, because they entirely depend on government for all the resourcing and other things. And because of sometimes their ad hoc nature, you are not even able to give them that kind of autonomy. Yeah, because there's no even time for that kind of autonomy. So they continue to depend on government for resources and other things. So if you are looking for autonomy, I think the committee, I would advise, focuses on whether they were autonomous with respect to how they discharge their mandate. Of course, I know some people can argue that if you are not financially autonomous, then you cannot also, it can affect your other autonomies. Fine. For argument's sake, yes. But really, I do not see any commission yet that is completely autonomous in terms of finances. Because that means we have to create the committee, let them come to National Assembly, their budget line be created, and then finance then pays money to them and nobody then deals with them. They have their money and they operate completely independently. That's not how these ad hoc committees operate. They continue to depend on us for a lot of things. Yeah.
We can appreciate, the committee can appreciate that response. Committee would just like to get insights on the inner workings of these things. However, I would put a proposition to you, Honorable AG, that after the establishment, of course, with the exception of MOJ 4A, wouldn't it have been perhaps more appropriate, if I could say that, for the secretary to communicate these impediments?
The thing is, the secretary might have been communicating to the ministry, but you realize that the ministry will be the one that like we talk about liaison. So for these problems to be taken to various government departments, it is the ministry that will be doing that. So the ministry will be aware of the problems, like I said, sometimes maybe through telephone call, through meetings. Now it is the ministry that will write to judiciary, write to finance, write to the police, depending on what are the issues, seeking for assistance. So that's why you will see the correspondence coming from the ministry. But usually you would have had a meeting or a telephone conversation with the commission, and then you are aware of the problem as their liaison, then you then do the bidding. So you call it bidding. Yes, the ministry will be, if it is money, it is us that will knock at the door of the finance ministry. If it is security, we will be the one that will contact the IGP, any other resources, like you see judiciary being contacted by the ministry. That's how it has always been.
Which is reasonable because, again, the MOJ would be the face of and the contact person between the commission and the government. So, AG, we have several other concerns. However, in anticipation of the fact that perhaps the resident facts would not be with you at hand, I would ask the Honorable Chair if we could permit the AG to proceed with those questions and give us written answers. At this point, we have exhausted our questions for this particular theme with regards to the Minister of Justice. I would hand over back to the Chair.
Thank you so very much, Council. And thank you, AG. Now we'll put the board to members of the committee as well, if they have any issue to clarify with regards to some of the responses that you have given. Perhaps to also shed more light. And so we have more questions coming from the members as well. So we'll be ready to. So we start with Mo, and then so you can come later.
Thank you very much, Chair, and thank you very much, Council. Yes, I just need some clarifications here based on the questions the Council posed to the Minister, particularly on the issue of the TOR to the lead Council. Now, when you look at MOJ 3K as alluded to earlier by the Council, that's MOJ 3K, which was the engagement letter. If you look at the letter, was dated 24th July 2017. Are we together? But then if you go further to the end of the letter, which is about the fourth page, where the Minister of Justice, the Solicitor General, actually confirms, you realize that the confirmation was made on the 17th of July 2017, when the engagement letter was actually drafted on the 24th of July. So it seems to me that the Solicitor General actually accepted even before receiving the letter, engagement letter. Can you just check? Are we together?
Yes. Yeah.
So the engagement letter from the Commission's Council was dated 24th of July. But then at the last page where the Solicitor General actually accepts the engagement is like a week earlier. So can you help us understand what's actually happened here?
I cannot really testify to this discrepancy. It's a plain discrepancy between the date of the document and the nature of one of the parties who signed and dated, and the signature happens to predate the date of the document itself. I cannot speak to that discrepancy, but I agree it's a discrepancy.
Thank you very much. That is fine. Maybe you can take a look at that. I think we've already made a request for the TOR of the Council because it seems the engagement came from her to engage, the ministry on the terms and conditions. Now, I would reiterate the need for us to have, maybe there was something that was sent to her before she came with the engagement letter, which I know is normal for the engagement letter, but then we need to be certain.
We will definitely look for that.
We need to be certain.
Yeah.
Yes, thank you. I think that's all I had on this particular area.
Yes, thank you very much, Chair. Chair, as per the answers from the Honorable Attorney General regarding the 180 days injunction, I was just wondering what happens when the order was not extended. What happens after that? After the period is elapsed, and then there are still assets, for example, movable assets. What happened? What happened to that?
So effectively, you will not observe that that order was obtained before the commission itself was created. So the order predated the commission. That's one key observation. Now, the 180 days interim period, if it expired and no further steps are taken to extend it, that will be the end of that. All the orders that are contained in that judgment or ruling goes with it. So it's like it expired. So it's of no moment. So for whatever you are going to do with respect to that injunction, interim, is to look at while it was valid, what had happened, not after it expired. Because when it expired, it's of no moment. But while it was valid during that 180 days, what happened? That should be the if I would say anything to guide the commission or the committee, that should be the focus. Because once the 188th day passes, then there is no order anymore. So it like you said, what happened afterwards is succeeded by different events. Now a commission is fully in place, and Ministry of Justice may have gone to court and obtained other orders different from this particular order. So there are so many other things that will be at play now, but we're no longer talking about that particular order because it has expired. Yes.
Yes, thank you very much. The other issue is about the TOR. Since we did not see any clear TOR between the Secretary General, in case of the Secretary General, and the chairperson, etc., etc.
The Secretary to the Commission.
Yeah, the Secretary to the Commission, and the chairperson to the Commission. Don't you think without a clear TOR between these two, the possibility of friction and duplication of role is possible between the two?
So when we have statute specify terms, they become the minimum implied terms for any given contract. In this case, we have seen Section 16 of the Commission of Inquiry Act gave minimum terms or TOR for a secretary to a commission. Of course, you could blow that up into a more detailed terms of reference. But in the absence of a detailed terms of reference, our fallback position will be that minimum TOR set up by law. So for the position of for the issue of secretary, we are not completely in a helpless situation because the law has prescribed minimum functions of a secretary to a commission of inquiry, which is statute. So even if they had developed a TOR, they can only build on that, but they cannot depart from that. If, for example, at the end of our search exhaustively, we are not able to find any TOR for the secretary, we have no option but to use that as the TOR of the secretary because that is statute. It's law.
Yes, thank you very much. As per MOJ 3R1, I was just thinking of this personnel, Alhaji Babu, Juf, Sanakama Gasama, and Andy Seka. These are people who are paid something like 1.8 million.
These are people?
These are,
I didn't hear you, though.
Detached. from their original offices. And they are also paid salary. That means that they should be paid salary, isn't it? And if they are paid salary, would that not give them 2 salaries from the state? Are they paid allowances or are they paid salaries?
So my understanding is for civil servants, over and above their salary, if they are going to get any remuneration, of course, subject to the approval of the Secretary General, could either be an allowance or an honorarium. Probably descriptions may differ, generally called honorarium or an allowance, but no, it cannot be a salary. You cannot have 2 salaries. Yes. So it could be some form of an allowance or an honorarium. Whether they were paid? If they had received any kind of payment, it wouldn't be a salary because it's not a permanent job that they have undertaken. So if they are paid anything, subject to how those payments are described in the vouchers, I have not seen their payment evidences. But I don't think I can close my eyes and say.
I'm raising the question because you said they are completely detached from their offices. That's what you said.
No. When I said the issue of detaching, at that time, the issue of these 3 individuals who are not mentioned, Council was leading me in a different issue. And I answered, I said, by my understanding, the staff that are attached to commissions for this kind of assignment are completely detached from the sectors where they come from. They go to work to the commission and they are completely physically detached. That was later when these three individuals' issues were raised. So, and the ministry, we have seen in their letter, they said they are working for the commission in addition to the work that they are doing within the ministry.
Okay, thank you.
Yeah.
Thank you very much, Chair. Honorable Minister, based on your response and on the question that are being posed to you by the lead counsel, at most the answer always short, I don't know. My question to you is, were there any time or was there any proper handing over to you, especially on this Jan Commission, to the one who was there before you?
Handing over, yes, but not specifically for Jane Commission. General handing over, yes.
Honorable Minister, you made mention about coming to the TOR issue. You raised Section 202.
202, yeah.
That's about the function and powers of the Commission. My question to you is, were they working based on Section 202, or did they develop anything after Section 202 as their TOR?
They have a TOR. That's the legal notice you hear council have been referring to.
Yes.
So there's a legal notice that broadly specifies their TOR. But that TOR is in tandem with 202. Because 202 is the constitution. The TOR cannot go against that. So you have the constitution that gave the general outline, out of which, because the section 202 of the constitution is not unique to a particular commission of inquiry. That's the general TOR for all commission of inquiry. Now, when you create a commission of inquiry, you know this particular commission of inquiry, the purpose for which you are setting it for. So then you develop from that general one, you outline the specific TOR for that commission. So both the constitutional TOR, which is general, and the specific TOR work together. So they complement each other.
So that specific TOR is with you. You have it with you.
That's the legal notice. Yes, it's here.
Okay, and then the other thing also,
that's it. It's the legal notice is here.
in your response also, I know it was not clear to me over, but I want clarity here.
Please, yes.
That's when lawyers are hired, they come with their own TOR or their own terms.
Okay, we don't call it in our business as TOR. But yes, in this case, fine. I think we can all conveniently call it that for this particular assignment.
Approved by who?
The client. You know, in a client-lawyer relationship, the boss is the client, not the lawyer. That is even ordinary life. If you walk into a law firm and hire a lawyer, You, the client, you are the boss. The lawyer for that purpose is your employee per se. That's why he's charging you a fee. You are paying the fee, but you agree on the service for which he or she is going to deliver to you for that fee. So that agreement is what is reduced into writing, and that's what you sign in the form of an engagement letter. So it's a contract.
So it's like that signed contract or that TOR that was being agreed by the client can be termed as it.
Of course, yes.
The working TOR.
Yeah, because in that contract relation, the client is more or less the employer.
And that one is existing.
Yes, yes. Again, yes, the council was referring to it during the questions. That is this engagement letter that we see was referring to.
Yeah.
Yes.
Yes. If you look at the issue of the staffs, some of the staffs we had deployed from your office to the commission.
Yes.
And then if you go to the lead counsel, according to the response on the, I think it was close, 3 JO3R1. She came with somebody called
Anna,
sorry, her own staff. Was it part of the deal, or was it that those people attached to her were not competent, or she or feel free to come in with anybody?
No, see, my knowledge to it is limited to what I saw in writing. And what I saw in writing, she said, a lawyer named Ananjai from my farm will be assisting me at no cost. And MOJ signed off on that. So me and MOJ have no problem in her co-opting one lawyer from her farm to support her do this job. That's how I saw it.
Thank you, Chair. Thank you, AJ. AJ, for the purpose of clarity, was the contract between AB & Co. and the Ministry of Justice, or between Ami Bensouda and the Ministry of Justice?
My opinion is between Ami Bensouda and the Ministry of Justice.
Then, why is the letter of engagement in the letterhead of AB & Co?
Yes, that's her farm. Oh, she writes her correspondence using the letterhead of her farm, was she signed off not as partner, which normally if the farm, my familiarity with the work that farm does, if she is signing on behalf of the farm, if you look at the signatures, you would have. But again, I mean, that I'm only expressing an opinion based on what I look at in the document. I believe she was engaged as a person, not as her farm. That's why she said, there's a clause where she said, somebody from my farm will be joining me to help me. If it were the farm, we wouldn't have seen that kind of clause in the contract. Because then all those working in the farm will automatically be part of the job. So there's nobody then need to come from the farm to support her. If the contract belongs to the farm, normally if a law firm is hired and they are hired as a farm, everybody in that farm are part of that. Anybody can do the job.
If you look at the last page of the engagement letter,
yes,
and you see where she signs off, it's yours faithfully, Ami Bensouda & Co. LP.
No. Okay.
That's on the last page.
Which I missed.
Yes.
Well, I still believe my opinion is she took this job as a person. And I'm not saying this is final or this is the most accurate, but my interpretation of this contract is she took the job as a person.
And that interpretation is right, because if you look at MOJ 3B rather, the contract, if you go to 3B, it says appointment as lead counsel to the Commission of Inquiry, and that was addressed to
exactly
Ami Bensouda.
Yes.
But if you look at the correspondence with regards to the letter of engagement, that's why we want to have clarity as a committee to know whether the contract was to Ami Bensouda as an individual lawyer, or to Ami Bensouda and AB & Co., or it was given to AB & Co.
My position is an individual contract.
So would it be normal
Would it be normal?
Is Ami Bensouda is a separate entity from AB & Co.
Yes.
AB & Co is a legal firm.
Yes.
So will it be normal if Ami Bensouda is given a contract for her to use the documentation of AB & Co to express her acceptance?
It makes the line blurred, I agree. But again, at this stage, for interpretation purpose, for me, putting these correspondence together, looking at the totality of the documents, my conclusion is it's still an individual contract. But I agree, I see where you're going. If it's meant to be individual, the importation of the details of a farm makes the line a bit broad. But to me, that still doesn't materially change the relationship.
I submit, Honorable Chair. Thank you.
Thank you, Chair. Mr. Witness, I just want to know, as per the Commission Act, what are the qualifications of a chairperson?
A chairperson, that is a constitutional issue. So on top of my head, for somebody to be appointed as a sole commissioner or as a chair of a commission, you must be qualified to be appointed as a judge, or you must have been a judge of the High Court. So you must have been one. A, if you are not a sitting or former judge, you must have met the requirements to be appointed a judge.
A judge of High Court or any court?
In our definition, yes, judge started from High Court going up. So judge of, if you say judge of the High Court, that's the minimum. Yes.
And we've heard you said several times that you lack the institutional memory, and as a result, you could not read
Certain things I cannot. Yes. Yeah.
And I want to believe the Minister of Justice is a permanent institution, and if there are records, if you and your team dig into those records, you should be able to provide this committee with the questions you have said.
Of course.
Are you going to undertake to do that? Come back to this committee with those answers?
I will find every record that you are interested in, because we are written to. You know, there is a correspondence between us and the committee. Any information that you want us to provide, if we find it on record, we will provide it, and we can speak to that record if we can see it.
Thank you. That's all. Thank you very much, Chair. Honorable Minister, just for more clarity, because it seems the answers we are receiving are not that specific, and the committee will appreciate if you can be specific in terms of providing us the answers that really we need. And that will lead me to MOJ 3K.
MOJ 3K.
On the issue of the appointment of the lead counsel. I just want to know from your end, from a legal point of view, in terms of communicating engagements, the one communicating, should the individual communicate as an individual or as a consortium or a firm?
So it depends on who you are hiring. If you are hiring a firm, they should communicate as a firm. If you are hiring as an individual, I believe they need to communicate as an individual.
In this case, I think the hiring is an individual.
That is my opinion, yes.
And equally, you know, what is shown on the record.
Okay.
So, for clarity purpose, let me ask once again. The appointment of the lead counsel, should the communication, that is the engagement letter, the addressing, let's say the addressing, should that really come from an individual or from the law firm that he or she is representing?
So you know, this is a lawyer that has a practice. I'm not too sure whether, because I don't want to speak to things that really I don't know. What informed her correspondence, knowing that the contract she is negotiating is personal, but chooses to correspond using her law firm's letterhead? Really, I cannot speak to that. I know she's an experienced lawyer. Probably this could be explained, but for me, from my interpretative point of view, it doesn't change the fact still that the contract remains an individual contract. So I expected that it will be communications will show that individual character. It will remain individual character. But unfortunately, what the records are showing something different.
Honorable, I think I didn't still get my answers. My question is from a legal perspective or point of view. What should be the right approach?
You see, I'm not too sure whether this is strictly a legal issue. I expected that correspondence should, if you are hiring somebody on a personal basis, you correspond with that person on a personal basis. But even for personal basis, individuals have addresses.
I have my answer, Honorable.
All right. Thank you. All right.
This time I would take reference from MOJ 5A.
5A.
Yes.
What is that about?
That is about the order.
Okay. That the court order?
Yes.
Okay, go ahead.
Yes. Honorable Minister, my question is, does the Ministry of Justice actually acted in accordance to the notice of the order?
What do you mean notice of the order?
You know, if you look into the content of the order, like for example, if you look at paragraph 2 and 3, there are certain responsibilities.
Yes.
Let's look at 4. For example,
4, yes.
Yes, for example, let me read. Paragraph 4, and I read, Chair, with your permission, that all the livestock held by or in any possession or control of the respondents, his servants, agents, associates, and family members or otherwise, whosoever be and are hereby seized pursuant to this order and are to be kept under the custody and control of the Gambia Livestock Marketing Agency pending the conclusion of the investigation initiated by the AG. Yes, so
I remember seeing correspondence to this respect. I believe it should be among the documents we submitted when the ministry conveyed this court order to Gambia Livestock Marketing Agency at the time. They responded back declining that they cannot take custody of these animals.
There is a communication that
I remember seeing
they
something.
decline.
Yes.
Are you in a position to share that communication with the committee?
The document we've shared. Council, did you see that among the documents? Check, but I believe that's among the documents we shared.
Well, we have received communication, but however, not from the documents that MOJ shared. We got it from Gilmer directly. Yes, but I would be preempting if I dilute on
There
that.
have been correspondence in this regard, so I will check if we have not submitted the ones that are in our possession. We will check them and make them available.
Yeah.
But I can recall seeing correspondence between Ministry of Justice and the Livestock Marketing Agency at the time. Yes.
Yeah, because I think we're also privileged to those documents.
Okay.
But then we haven't seen anything of that nature, any communication from Jelma kind of declining.
Oh.
Yes,
Okay.
I haven't seen anything. Let me
We
speak
will
on my
look for
behalf.
it.
So
I try to remember, but I'll confirm this.
okay. Now, if just a final one. Yeah, a final one, yeah? Because that would go with regards to staffing at the council. or at the commission rather. Because I am privileged to certain evidence that some of the staff, like a particular permanent secretary who was deployed at the commission without following the due process in terms of, one, appointing her, two, in terms of getting her a clear TOR, and three, seeing her receiving salary from government and a honorarium from the commission. From a legal point of view, what is your take in that?
So what is the question?
The question is having someone given a responsibility without following the due process in terms of appointing the individual, and also having that individual going out for a secondment and still receiving, let's say, a salary from government and a honorarium from the commission.
There are procedures for all of these things. I expect them should have been followed. And like you likely referred to the due process. So I expect when such deployments are done, due process should have been followed. So if they are not followed, it means the process was wrong.
All right. AG, before we proceed to council again for more other questions for today, I just wanted to highlight something. I remember the council was asking you about budget and you responded about the budget of the commission. Now, the budget of the commission is submitted to the Office of the Attorney General, Minister of Justice. Is that right?
I cannot confirm for this commission, but I can say that should be normal, yes. So I can check whether that has happened in this case, but I believe, yes, that's the only line ministry that should receive their budget. But whether it was done or not, I'm not too sure. But we can check that out.
So, but meaning you haven't seen any documentation?
I'm not too sure whether among the documents we submitted a budget is included, but we can still check.
All right. I think that would be important.
Yeah.
For us to have.
Yes, sure.
Okay.
Yes, Honorable Chair, we have exhausted our questions. However, I would want to pose one
relating to Gelma.
Yes.
Because they are supposed to take care of this, take control of these movable animals.
Gelma,
So-
the animals.
Yes.
Animals.
Yes.
Yes.
And if they have not done, what happened?
So the early answer I was giving between Gelma and wildlife, one of them responded that they could not. I remember seeing this. So I stand to be corrected. I'm not too sure the response I said I saw was either Gelma or Department of Parks and Wildlife, because both of them are mentioned in the court order to take care of different animals. Now, your question is if, for example, it was true they were informed that the court ordered them to do this and they declined to do it. It's contemptuous to disobey a court order. So, because I believe if there are genuine reasons for not being able to comply with the order, the court can be approached again for an order to be varied. But if the order has not been varied and remains valid, and the person to whom the order has been directed to would have no option but to obey it.
Those things happen. The court did not vary, and then these people also did not take care of, take control of the animals. What happens to the animals?
So like I said, for the period for which the order has been valid, there would have been a total abdication of responsibility for that period. Yeah.
Honorable Minister, thank you, Chair. I think it's good that we have you here. My question is, do the council has the legal authority or mandate to engage in the sales of former president's properties or livestock?
You mean council or commission?
Commission.
This is it's a loaded question because there's a lot even in the legal fraternity about that issue.
Honorable, now what will do, AG? I am being told maybe that question is relevant for this committee. However, I would have asked the member to save the question for now.
I believe so.
Yeah,
because it's core to your function, so your job, the inquiry that you are doing.
Exactly. Honorable, thank you. Thank you for the question. Back to you, lead counsel.
Thank you, Honorable Chair. Just to re-utter the words of the Chair, the information, Honorable Attorney General, definitely need you again. And this was just to, so to speak, lay the foundation.
Okay.
And understand the mind of the government pre-establishment and understand the establishment of the commission. We have exhausted questions. I would, however, pose to the AG the question of whether all documents relating to the commission were submitted to the assembly. Every single iota of a relevant document.
No, we were. I think the team acted on the summons, based on what is outlined in the summons to produce. So as the inquiry continues, because anything that you ask, we will exhaustively, I can assure you that. I've given clear directives. I'm not sure whether you're with me. So I've given clear directives. Anything that you need and is within our possession will be provided. That's a given. Don't doubt that. Anything that you could not receive from us, then we cannot find it.
Honorable Chair, back to you for closing.
All right. Thank you so very much, Council. Thank you, Attorney General and Minister for Justice, for your presence. Like I said earlier in my statement, I think your appearance is important for this committee.
Thank you.
Because what the committee is doing is trying to find facts, and these facts are relevant for the public as well. So, as part of our job and the mandate that is being established on this committee is to bring on witnesses to come and testify, just like you did. And we thank you for coming and then, giving us your testimony for this very important job. I also want to thank my colleagues in the committee and, of course, the support staff for today, the media, and everyone in attendance. So we'll be closing for today until tomorrow, 11 o'clock. Thank you.